Hey guys, it's Dad with Dad's Guide to Adulting. I hope you're doing well and having a great day. Today we're going to talk about financial or business powers of attorney. Now, even if you decide as a young adult that you don't need a will, it's a very good idea to have a financial or business power of attorney in place. Basically, what this is, it's a document that allows someone else you trust to handle your financial affairs in the event that you can't because of some sort of medical condition. If you're in a coma after a car accident, if you have a stroke, if something terrible happens and you're unable to function, you need somebody else you trust to handle all of your affairs until you get better. And that's what this document is. There are a couple of different basic categories of powers of attorney in the financial area. And one of the differences whether it's general or limited. A general power of attorney gives someone the authority to handle unlimited matters. Anything you can handle, they can handle. A limited power of attorney gives them authority only to handle certain things, certain specific matters. So you can decide now which one you want. A general is probably better if you're talking about a situation where you're incapacitated. There's also a durable versus a non-durable power of attorney. A durable power of attorney is one that allows your agent, the person you've chosen to act for you, to act if you are incapacitated. So if you are in a coma, the durable power of attorney lets your agent still carry out your affairs. A non-durable power of attorney does not operate if you are incapacitated. It basically gives someone the power to act for you for a limited period of time, but if you are in a coma or incapacitated, it wouldn't apply unless you have a durable power of attorney. Those are general rules. Obviously, they differ from state to state, but those are sort of the general rules. One of the things that's very important to understand is that you need to sign this document while you are still in good shape. Obviously, it's not going to work if you wait until you're incapacitated and then want somebody to handle your affairs. You have to sign the document while you are competent. And if you're thinking about getting something for your parents, remember, you need them to sign it before something happens that makes them legally incompetent. Once they're legally incompetent, they can no longer sign documents, so any power of attorney that they sign would be ineffective. You can set the conditions in the document for when it would become effective and what kinds of circumstances would trigger it. You can also revoke it at any time. It's a good idea, if you have these documents in place, to check them from time to time and make sure that you're still comfortable with the person that you've chosen to handle your affairs and with the scope of everything you've allowed them to do. You can also spell out in the document what you do and do not want them to have the authority to do. For example, you might authorize somebody to pay your bills but not to sell your home. Other typical categories include whether they can invest your funds, whether they can make changes to your insurance policies, those sorts of things. Keep in mind that the person who you choose to act as your agent has fiduciary duties to act in your best interest. A fiduciary duty is a duty under the law that's the highest ethical and moral duty to act in somebody else's best interest. So make sure that you choose somebody you trust. A power of attorney is a powerful document. It basically gives somebody else a lot of authority to act in your stead, and if they make decisions that you don't like once you recover, it's too bad. You're locked in because you gave them the authority to act as if they were you. In light of that, it's very important to choose somebody you trust implicitly in that role before you do anything. If you end up being in a situation where you are not merely incapacitated, but you actually die, the power of attorney would no longer have any effect. Then your will goes into effect. If you don't have a will, then your estate would be governed by the laws of intestacy, meaning that the court would determine who would handle your affairs and where your assets would go. They do that in accordance with state law. So where do you get a power of attorney? There are a few areas where you really do need a lawyer, and this is one of them. Just like with wills, you don't want to print out a document off the internet and fill it out yourself and hope that it works. State law tends to be very specific about how these forms are drafted, what they can and must contain, and also how they are signed. If they're signed improperly without the right number of witnesses or without a notary public, it may become ineffective. You do want to talk to a lawyer whenever you're talking about putting a power of attorney in place. The kind of lawyer that you would look for is typically a trusts and estates lawyer, or you can find an elder law expert. They take care of people who are in the late stages of their lives and have lots of specific issues, and they're very well familiar with how to draft these powers of attorney. So how do you sign it after it's done? Again, that needs to be done in accordance with state law. Signing a legal document like that is called executing it. So a signed document is oftentimes called an executed document. And every state has different requirements on how that is done. Again, make sure you talk to your lawyer. So those are the basics on financial powers of attorney. I do think it's a good idea for everybody to have those in place even when you're a young adult, just in case you ever need it. In our next video, we'll talk about medical advance directives. Until then, remember, you got this.